Hello, and welcome to part one of our second talk on digital health, this time looking at AI, data, and some of the wider IP considerations. My name is Jack Severs. I'm a UK and European patent attorney at Gill Jennings Every. GJE are a specialist IP law firm with our main office here in London, and we advise a wide range of clients on patents, trademarks, and design rights. I lead GJE's medtech sector group, and so a significant part of my time is spent advising health tech companies on how to protect their innovation. Today, we're joined by Ben Williams, an experienced solicitor advocate at Withers Tech, the specialist technology arm of Withers Worldwide, a full-service global law firm. Withers Tech specialise in advising high-growth technology companies across a range of industries, particularly including health tech and artificial intelligence, relevant to the talk today. Ben and I have worked together on a number of projects now, including providing support to a number of accelerator and incubator organisations in London, including the Digital Health London Accelerator, to advise early stage companies in particular on how best to protect their digital health innovation. Now, one of the categories of digital health technology, which is a particularly growing area and one that we see fairly frequently, is the application of machine learning, or AI more generally, to the analysis of patient data. As we'll recap briefly later, generally this type of technology is considered patentable. However, as Ben is going to explain, often there are other crucial issues that need to be addressed, particularly around whether you are able to use patient data as needed within your business plan. So we've invited Ben to share some of his expertise in this area and to set out some practical advice around some of the wider IP issues, particularly covering the use of patient data in several example business models. So I'll hand over to you to give us a bit more of an intro about what you'll be discussing today.
Yeah, thanks, Jack. I thought we could perhaps start by breaking down what a digital health company is from a legal perspective into its various different component parts. In my experience, a digital health provider is almost always either a data-driven, self-contained software platform, or primarily a data-driven software platform with some hardware components, which are usually off the shelf or have minor bespoke elements, and help either collect and capture the data or deliver the service to the recipient. And those various elements come together in the form of a web application or a mobile application. So immediately we've got several things to think about here. We've got to think about the protection and supply of a software system and everything that goes with that. Possibly the protection and supply of the hardware. And crucially, one of the frequently overlooked assets of a digital health business is its data and its data pool. So we're going to look at capturing that data, how that is done, or if it's imported from a third party like the NHS, how that should be covered. We'll look at how that data is processed, and then we'll look at how the data makes its way into the output, so the service that's delivered to the recipient. We can also think about what a digital health company does by looking at inputs, processes, and outputs. For this part one, we're going to be exploring data rights and exploring thorny issues around patient data, and answering questions like, do you have the correct rights to use your patient data? Really fundamental issue. And can you improve your artificial intelligence system? Can you train those algorithms with patient data? So we'll be looking at that in part one. If you want more information about the protection of software and artificial intelligence systems, or the ownership and analysis and improvements, then that will be in part two, as will the liability of artificial intelligence systems. But for present purposes, we're going to be looking at the data. And when we're talking about data, I think it's really helpful to distinguish between data that's regulated by the GDPR and other privacy regulations, and unregulated data. And I've got a slide here which will help us do that. So regulated data, we're really talking about personal data. Personal data is any data about a living individual that can, from that data, be identified. Now, there's clearly some obvious examples of what constitutes personal data. Things like somebody's name and their address, their date of birth. That's all very straightforward. There are some less obvious examples, things like an IP address, location data, or identification numbers. They're all to be treated like personal data. But what about things like symptoms, for instance, a list of patient symptoms? Well, where non-identifying data, like a list of symptoms, is captured alongside identifying data, like somebody's name, then all of that data is to be treated as being regulated by the GDPR. And the reason for that is because data about an individual, there is data there about an individual that can be identified. You've got the name and you've got their list of symptoms, and you can tie those two things together. So unless and until the identifying parts in that data set are completely deleted and are not accessible by anyone in the company at all, that is to be treated as personal data. There is a slight complexity to add there, and that's this concept of pseudonymized data, which is also regulated by the GDPR, but differs from being personal data because the personal identifying aspects of that, so in that example, the name, the address, the date of birth, they have been deleted but are held elsewhere by the company, perhaps in another database. So when you do that, you've removed the identifying data, but it's held somewhere else by your company. That is to be treated as pseudonymized data and will be regulated. If we look at the unregulated data, unregulated data is things like anonymous data. So if you have your personal data and you delete any identifying part of it completely, no one else has access to it in the company, it then becomes anonymized. It moves outside of the regulated remit and is to be essentially unregulated. And there are other categories of data too. So for instance, technical data, statistical usage data, and analytics data, provided they don't identify the data subject, for instance, by means of an IP address, then that's to be treated as essentially unregulated. So now we're going to look at whether you have the correct rights to use patient data. And to do this, we're going to look at 3 different business models because it really depends on how the business is set up. So we're going to look at a straightforward kind of B2C, business to consumer model. We'll look at a B2B model, and then we'll look at a B2B2C model. To start with, let's take the B2C model, where you have an artificial intelligence-based software system which is delivered via a web app or a mobile application directly to a patient. Personal data will almost always be collected directly from the patient because they're the user, along with other data like analytics data and technical data. In that scenario, it is highly likely that you will be a data controller for all of your activities. A data controller, just to explain that term, is the legal terminology for a person who decides what is done with the regulated aspects of the data we previously looked at. And that's a really important concept because the controller is primarily responsible under the GDPR for its compliance. And what does that mean? Well, it means in practice that if you are operating a standard, straightforward B2C business model like the one shown here, you will need a privacy policy, which explains exactly how the data is used in quite a granular level of detail. It must set out the lawful basis of the processing for all of the categories of data. So not just what you do with it, but what legal rights do you have to do that. And they will also have to include extra rules because you're likely to be capturing health data, which under the regulations are considered to be special categories and therefore subject to more onerous regulation. The practical effect of that is probably that you would need to capture consent from the patient that you're able to use that health data as you wish. I'm often asked about the consequences of getting the privacy policy wrong. So what happens if we have a privacy policy, but perhaps it doesn't explain all of the uses of data, or perhaps it doesn't set out properly the lawful basis of processing? What does that mean in practice? And I think the answer to that really is that in addition to the potential regulatory breaches, which is clearly not an ideal position to be in, there are other practical and undesirable consequences. The most important one being that you cannot lawfully use any data that is not properly explained in the privacy policy. The legislation is pretty clear about that. That means that on perhaps an external investment round or due diligence on an exit, this is likely to be something that an investor or a potential acquirer asks you about, is likely to come up, and is something that will have to be addressed. So practical advice really is invest in your privacy policy if you can. Make sure you capture all of the correct permissions to use that data, and if you get it wrong, make sure that you fix that as soon as possible. And periodic reviews are highly recommended. So that was the business to consumer model. If we now look at the slightly more complicated business to business model, you've got same platform being delivered to, in this instance, a commercial entity, perhaps the NHS, a GP surgery, an insurance company, perhaps. Each one of those entities will deal with the patients themselves. So the flow of data will be from the patient to, in this instance, the NHS Trust. The NHS Trust would then pass that data on to you, and there would be a degree of collection of that data. So just to add some colour to this slide then, we're thinking about here perhaps something like a mobile application which helps doctors diagnose patients. So the doctors are the one using the application here rather than the patients themselves. So it's a tool to help doctors. This scenario differs from the first model we looked at because the digital health company here is highly likely to be a data processor rather than a data controller, because it is getting its data not directly from the patient, but from a third-party entity, so perhaps the NHS Trust in this example. That leads to a conclusion of a slightly more complicated contractual structure. In addition to a privacy policy, which you'll see down the bottom there, which is required for things like user account administration, customer support, that kind of thing, where you're using doctors' data directly, you would need a customer agreement, which would be in place between you and the NHS Trust, to obtain permission to use the non-personally identifying data, that's the unregulated stuff, to perform the services and for all other purposes for which you require. and you would be expected to enter into a data processing agreement, a DPA, under which you would need to obtain written permission for every use of patient data. And we can come on to what we mean by that a little bit later. And the third model I wanted to look at was what we call a B2B2C. So that's where we have a web or mobile application which is sold into a third-party entity and white labeled and then used directly by a patient. This is a slightly more complicated level again, because you've got users at the NHS level or the entity level, and you've got users at the patient level. And so there is personal data being captured at both of those levels and two different means of data flows, in addition to the technical data that's captured by use of the mobile application. So the model itself is more complicated, but the conclusion is the same as a B2B, really, and that is that you would likely to be a data processor in all instances except for the provision of user accounts and providing customer support. And therefore, the same documents that we've previously seen would be expected. So a customer agreement for unregulated data, a data processing agreement, a DPA for regulated data, and that's the really important one. That's the one you really ought to invest in getting right. And the privacy policy, where there is direct capture of data from the entity. Okay, so the next thing I thought would be really helpful to look at, and a common question, is can you improve your artificial intelligence system with patient data? So can patient data be used to train the machine learning algorithms? And again, it depends on the precise business model that's at play. In a B2C scenario, it's relatively straightforward, though. The answer is yes, you can improve your artificial intelligence system with personal data, including regulated personal data, so the identifying stuff, provided that your privacy policy allows it. And as mentioned, that may require an additional technical step in the delivery of your service to make sure that you're capturing the correct consents directly from customers, but it's certainly possible. It's more complicated, however, in a B2B and B2B2C scenario, precisely because you're not the data controller and therefore not the ones making the decision about how the regulated data is being used. So the way that most of our clients get around this potential issue is to make sure that in the data processing agreement, they capture the consent to de-identify any personally identifying data and only ever use anonymized data to train the artificial intelligence system. And as long as you do that, that is considered to be an imperfect but practical solution around the issues. If, however, you require identifying personal data to train your artificial intelligence systems, then things get more difficult. You are likely to run into issues with the data controller, who will probably not want you to do that, and that will take a large degree of explanation. But if that is the case, you would then be considered a data controller in your own right, and therefore would be required to put in place things like a privacy policy and send a notification to every patient setting out exactly what it is that you're doing with their data. And to the extent health data is required for that purpose, you would again need to capture that additional level of consent.
Thanks, Ben. So that concludes part one of this talk on digital health, which looked at AI-based technologies and the contractual rights required in order to use patient data in the way you need within your business. You can find the second part of the talk on GJ's YouTube channel. in which we'll cover how you can protect your technology and ensure that you own the improvements derived from the data that you don't own. If you'd like to find out more, there's lots of information available on both the GJE and WithersTech websites. You can see the addresses on the slides there. And please also feel free to get in contact with myself or Ben via email or connect with us on LinkedIn. I'm sure Ben would be happy to answer any specific questions that you have about your technology and to discuss in more detail. Thanks for listening.